So, how did you come to specialize in law and religion?
You know, I was a civil rights guy, basically. I was writing about race and disability and gender issues, and I had a strong background in that, and was writing in civil rights and employment discrimination. But my first conference talk was about actually civil rights issues that arise when school prayer that occurs in a way that violates these United States decisions from 1962 and 63. And many districts in more homogeneous areas of the United States regularly violate these decisions and have school prayer. I was interested less in the constitutional aspects of it and more what happens to the kids who are different in those areas. And what I uncovered was a horrible history of discrimination and violence, not only against the kids in these districts, but also against the families when they protest. And so it was a piece on the civil rights aspects of school prayer, what happens to religious minorities. And it ended up becoming my first book. People like the conference talk. And suddenly I found myself being a law and religion person, and I just fell in love with it. I just fell in love with the field. And I love it. I just kept doing it.
Interdisciplinary study has long struggled to find a place in the academy for a variety of reasons. Perhaps you could say something on how important you believe interdisciplinary study has been in your career, and how important interdisciplinary study is to the academy as a whole.
I'd say I don't know that I would have as much of a career, if any, without interdisciplinary study. I think what's made things that I've written maybe better received or more interesting is the fact that I don't think you can look even at law and religion, you know, in a vacuum. You can look at the law, you can look at the religion, you can look at, you know, just what do the courts say? But you really can't understand the dynamic surrounding it unless you're really familiar with not only legal philosophy and not only religious studies, but you have to be familiar with interpretive philosophy. You have to understand how courts interpret. And I think that, like in many fields, the social sciences have a lot to offer in terms of theories as to how people behave and how that affects conduct in the areas where law and religion are interacting. To me, you can create an artificial world if you want to. You can, in anybody, and we see it in academia all the time. And it doesn't mean these people are bad academics. I mean, but I think it's very artificial. You can create your little bailiwick and close off the walls, right? You can say, I'm going to understand my field from within my field. And to the extent that I look at it from outside of my field, my entire perspective on what's relevant outside of the field is going to come only from my view from within the field. To me, that creates these little artificial pockets of intellectual existence that are fine, and you can learn from them. But when those pockets talk to each other, and when there's interaction, everybody learns more. And interdisciplinarity, to me, it's not just something that informs my research, but it informs the way I even look at research. It informs the structure of everything that I do, because I realize that if I create this little artificial bailiwick in which I exist, I can only look at, you know, a problem from this one limited perspective, and I may not understand the dynamics underlying the problem. And part of that in law, there's the formalists and the realists. I'm more of, I guess, what you would call a realist. We're interested in the real world impact. But I think even for formalists, you know, they have to be familiar with philosophy at the very least. So I think interdisciplinarity, it's essential if academic growth isn't going to be stunted, particularly as we move into the 21st century, where information is readily available, where crossing disciplines is easier to do, where universities, like my university, Michigan State, is wonderful at promoting interdisciplinarity. But even if you're somewhere where there just isn't a focus on that, you can do it yourself because of access to information. Now, you shouldn't be publishing anything until you have consulted with the proper people and understand what it is that you're, if you're working with another field, what it is that you're doing. But I think interdisciplinarity it's the future. But it's also, I think, necessary. I don't think, almost everything that can be said about some fields from within the field has been said. But interdisciplinarity opens up so many other possibilities between fields and through that within the fields.
How did you come to be interested in this particular constitutional issue? Because your background as a lawyer and a student of law in the United States, perhaps you could say something on how you came to be interested in this issue, and also the difference in the establishment of the Japanese Constitution in relation to the US Constitution.
Yeah, it's interesting because I'm a US constitutional law scholar, and that's what I've been doing for many, many years. Obviously, I've had strong connections to Japan as a Fulbright scholar and then running a program here. And over time, I was very interested in a different area of Japanese law and religion involving the free exercise of religion. And I looked at a relatively famous case called Matsumoto v. Kobayashi, or the Kobe Technical College case. And I actually wrote an article on that comparing it to US free exercise law and suggesting that the Japanese Supreme Court, in that case a petty bench of the Japanese Supreme Court, did a much better job grappling with the underlying issues of what it means to exercise religion than the US Supreme Court did in a case called Employment Division v. Smith. Many refer to it as the peyote case. And I actually wrote an article about that, and I thought, wow, that's interesting. It ended up in a really good symposium. I gave some talks about it, and I found it very interesting. So I then spent a few years, sort of as a hobby, actually, studying Japanese constitutional law on religion. I mean, I'm not a general Japanese constitutional expert, but Articles 20 and 89 in particular, and began finding that there were some really interesting issues surrounding the Japanese concept of seiji to shukyo no bunri, or separation of religion and government, and began writing articles actually on that, a couple of articles. And I think looking at the Yasukuni issue was almost a natural next step, because I became very fascinated with this Ehime Tamaguchi case, which to me, when I read it, it seems to be a massive change in Japanese establishment clause, if you would call it that law, or the concept of seiji to shukyo no bunri. And in the Ehime Tamaguchi case, the court looks at the issue historically and constitutionally, but very deeply and carefully. And it actually orders somebody to do something, which is uncommon. In Japanese Supreme Court opinions will frequently discuss the law, but not necessarily order anybody to do anything. And this case did all of that. And so it stood out to me as an important case. And thinking about more recently Shinzo Abe's visits to Yasukuni, and then some of the cabinet ministers last year visiting, it occurred to me, that I should look at the lower court opinions on this, and they're not really translated, so I needed kana translation so I could at least read them in kana. My kanji skills are terrible, and it occurred to me reading those that the Osaka High Court, in its opinion, that found visits to the Yasukuni Shrine unconstitutional, also looked at the issue very deeply, and the other courts that went the other way didn't. So it struck me that this was a really interesting issue, and maybe an article or talks about it would call attention to, maybe it would be something that a court would look at. Even if it was written in English, maybe translated into Japanese, it may be something that the court would at least think about. In terms of the connection to US constitutional law, I also find that fascinating. I think that the Japanese courts, but also I think Japan in general, even in legislation, has done a better job, ironically, because it's a much more homogeneous nation, but it's done a much better job under the new constitution with free exercise of religion. And I think that's the interesting thing, because the current Japanese constitution was imposed on Japan by America in the 1940s. And the Japanese Supreme Court in Ehime Tamaguchi, but in other cases as well, has sort of pointed out that it's got to be interpreted in light of the Japanese nation and the Japanese people. And so in a way, the court has made it its own. And in the free exercise of religion area, which is another religion area, the Japanese courts, Japanese legislation they really have made it their own. Article 20 of the Japanese Constitution provides much more robust protection for the free exercise of religion, not just in terms of court interpretations, but in terms of legislation as well, than exists under the US Constitution. Although in many American states there's very strong legislation protecting free exercise. We call them RFRAs, Religious Freedom Restoration Acts. But I find in Japan it almost seems to more directly come from the Constitution. The court has rejected this Employment Division v. Smith case I mentioned, which is very problematic for religious minorities, people whose religion involves practice that isn't commonly considered when legislation is made. In Japan, that's not a problem. The Japanese Constitution has been found to protect religious practice, even when it's different from the norm, in a country that values the norm very heavily and that is very homogeneous. So it's remarkable to me that distinction in free exercise of religion. And so it's a natural for me to be looking at the establishment issues as well. And it's fascinating. To me, the concepts are similar because the US concept was imposed on Japan. But the interpretations, even using similar language in tests, tend to be very different. And it's fascinating to watch how the Japanese courts kind of in a way make it their own. And they don't know, I mean, it doesn't mean there's no right or wrong necessarily, but it doesn't mean the Japanese courts always get it right. I think the Sioux City decision misapplied Article 20 and 89 under its own test. The test the court laid out actually was, I think, but that happens in the US as well. We see courts laying out tests and then applying them in a way that seems completely inconsistent with the test. And in Japan, that's happened as well. It happens in religion cases around the world quite a bit.
Professor Ravitch, can you give us a brief summary of your keynote speech?
Well, I was looking at the Yasukuni Shrine issue, and it's a really important issue because it's got legal, religious, geopolitical, but also Japanese political aspects to it. And the focus of the talk was not so much on the shrine itself, but on the constitutional issues that visits by the PM of Japan or other high-ranking officials raise, because Japan has a concept of seiji to shukyo no bunri, or separation of government and religion. But it's a concept that's been played out in a variety of court decisions. But in the Japanese Supreme Court, in one decision, this case called Ehime Tamaguchi, sort of draws a distinction between official connection to the Yasukuni Shrine and sort of what might be called Shinto as culture, So like another famous case involving a local groundbreaking ceremony. That was held to be constitutional. It was sort of viewed as part of what Japanese people would perceive as normal part of the daily life, and not something that was really fostering religion. Now that decision on the groundbreaking could be questioned as whether or not it's an accurate interpretation. But the interesting thing is the one case involving the Yasukuni Shrine, the court found that there really was a significant difference between government officials making offerings at the Yasukuni Shrine versus sort of local regular Shinto. And they went into the history of state Shinto and found that there were significant problems. Now, that case did not involve the prime minister or anything like that simply visiting the shrine. It involved local officials coming from a prefecture and giving offerings with government funding. But I think the case has a lot to teach us about possible outcomes if the Japanese Saiko Saiban or Supreme Court were to make a decision on visits to the Yasukuni Shrine. In the lower courts, it's been split, but the Osaka High Court held that former Prime Minister Koizumi's visits were unconstitutional. And of all the High Court decisions, which are, in Japan, the high courts are actually a step below the Supreme Court. Though, of all those decisions, the Osaka High Court's decision actually makes the most sense. It grapples with the constitutional issues in a more open way. And so my sense was that constitutionally these visits are a problem, but that also is an opportunity for the court to sort of have a teaching moment. As it did in the Ehime Tamaguchi case. It gives the court the opportunity, in an opinion, to tell the world and the Japanese people as well, look, there's a reason why visits to Yasukuni are a problem. Articles 20 and 89 were developed as a result of state Shinto, and Yasukuni has a connection to that. There are significant aspects of Japanese culture that are inconsistent with these visits. And part of the test constitutionally is whether a visit to a shrine or a groundbreaking ceremony is something that's consistent with the nature of the Japanese people and what people would view as either religion or more sort of normal culture. And the court would have an opportunity to say something about that. And that would both be a lesson about what the Japanese people think for those looking at Japan from outside, because the legal test for separation of religion and state involves looking at what Japanese people would find to be sort of a normal part of daily existence or normal part of life, but also within Japan, it would be a very good teaching moment. So that's sort of an overview of the talk.
US Supreme Court Justice Clarence Thomas argued that the Constitution was colorblind. Is it?
Well, it's interesting. Thomas has made that argument. Justice O'Connor made that argument. I find it a remarkable, and not in the good sense of the term, argument that the Constitution is colorblind. What does that mean? First of all, the Constitution itself was not colorblind. It recognized slavery in its initial form. The amendments that got rid of slavery, the 13th, 14th, and 15th Amendment, those amendments were, when you look at their history in particular, which is something that Thomas is very focused on, is originalism and the intent of framers, which would include the framers of these amendments. It's clearly not colorblind. The original Constitution, not even the text was colorblind. In the 13th, 14th, and 15th Amendment, you might argue the text is colorblind, although when you consider the situation to which it was addressed, particularly the 13th and 15th Amendments don't appear to be in, and the 14th as well, clearly has at least the argument that it's not, when it comes to issues of race at least, that it's not colorblind. It's designed to protect people. The argument that the Constitution is colorblind is an argument that is used to harm, in many ways, minorities. When somebody says the Constitution is colorblind, they're making an empirical statement. And there's three possibilities. Possibility number one is they're strictly talking about the language of the Constitution, in which case they're wrong because it simply wasn't colorblind. We know it recognized slavery. This not a good thing. Two, they could mean, again, maybe the intent, the interpretation of it. Again, we know that isn't colorblind. Three is they could mean it's designed to be colorblind in our society, but our society, American society, isn't colorblind. Even today, racism is still rampant in America. With the amount of racism that we still have in America, I think it's a very naive notion to say that the Constitution is colorblind. And I'm talking about the third aspect here, the idea that society is somehow colorblind. Thomas is going to say, that's not what I mean. I don't mean society. I mean that we have to look at the Constitution, just the Constitution, and it's colorblind. But empirically, he's just wrong about that. I mean, it's just an incorrect statement. To the extent that he's saying it's an ideal, and that is something that Justice O'Connor has said, I believe Justice Thomas has said that as well, is that it's an ideal of the Constitution to be colorblind. Well, I mean, now you're getting out of your own area, right? I mean, Justice Thomas is always saying we should look at the text and the history. Well, if those aren't colorblind, then how do you know the ideal was colorblind? We know the 14th Amendment was at least passed in part to protect the former slaves. So it was in part created to protect people based on race to a point. And so if this is the ideal, where are they getting this from? It seems that they're getting it from their own political perspective, which is no different than somebody who gets the idea that the Constitution needs to account for race to help undo racism. You mentioned interdisciplinarity before, and I think here is a really good example. I look at what the sociologist Troy Duster has said, and he has this great analogy to a poker game. So I've been playing poker with you, and I've been cheating the entire game. And I have this big pile of chips in front of me, okay? And, Duster makes the analogy that this is sort of race in America, that whites, for all those years, because of slavery and then Jim Crow, segregation, and then after that, discrimination that wasn't dealt with, piled up all these chips. And the colorblind Constitution analogy says, yes, but we stopped cheating. We stopped cheating. So now we have to look at everything colorblind. So here you are sitting there with very few chips. And now here I am with all these chips because of discrimination and so forth. But now suddenly we're colorblind. So we can't even account through affirmative action or other things under Justice Thomas's concept for giving back any of the chips. And so to me, the colorblind Constitution, the colorblind society notion is based on this idea that now new players have come to sit in the seats. So you weren't the direct victim of Jim Crow, and I wasn't the one causing the segregation. But the reality is there is this thing that Troy Duster and others talk about called white privilege in America. And that means that I come and sit with a bigger pile of chips. So to me, the whole concept of a colorblind Constitution, A, ignores what the Constitution actually says, B, ignores the history of the Constitution, including the 13th, 14th, and 15th Amendments, and C, ignores the underlying political elements that someone like Justice Thomas or Justice O'Connor needs to say that the ideal of the Constitution is colorblind. And of course it ignores social reality.
Could you tell us about the Amicus Briefs you've written to the US Supreme Court?
Yeah, I've had a chance to write a few Amicus Briefs to the US Supreme Court, and it's been in things that you might expect for someone like me, school prayer cases. I'm part of the group called the Scholars and Historians group that have filed a number of briefs in law and religion cases to the US Supreme Court. And I've wrote one brief on separation of powers under the Constitution. It's one of the joys of being an academic in the law, which is, you write books and articles, and so sometimes you find out people actually read them. And you get the call from a lawyer or a judge or somebody who says, could you write an amicus brief? We found something you wrote really interesting. We'd like to get that perspective before the court, maybe in a brief or something related to it. And you get a chance sometimes to actually have some influence, maybe, if the justices read the brief and find it useful. And so I've had that opportunity a number of times. My favorite one was in a school prayer case that was a sister case to a case called Santa Fe v. Doe back in 2002, and I got to address an issue that the court ultimately directly dealt with in Santa Fe v. Doe regarding the relationship between free speech and freedom of religion. I don't know whether the brief, influenced the decision or not, but I know the brief was in the sister case, so it would have been read along with the briefs in Santa Fe v. Doe, they came out the way that I had hoped. So whether it influenced them, I don't know. But I like to think that, who knows, maybe someone read it and got an idea. But it's a great joy. We can do praxis as legal academics. We get a chance to actually get out there and maybe influence the courts, which is, you try to do that through your writing. You want the courts to read what you write and be influenced by it. But you can also do it through amicus briefs, which are friend of the court briefs. And I really enjoy it.
Professor Ravitch, thank you very much.
You're welcome.